All rise. We will away. The International Criminal Court is now in session. L'audience Cour pénale internationale est ouverte. Please be seated. We will as well.
Yes, good morning all. Actually, we'll start with the prosecution this morning.
Good morning, Madam President. Good morning, Your Honors. Good morning to everybody in the room. We are the same composition as yesterday. Thank you.
Thank you, Mr. Nichols. The representatives of the victims.
Yes, good morning, Madam President, Your Honors, dear colleagues. Good morning to everyone in and around the courtroom. The composition of our team, the legal representatives of victims, is the same as yesterday. Thank you.
Thank you very much, Mr. von Wistinghausen, and the defense.
Good morning, Madam President. Good morning, Your Honors. Good morning, colleagues. Same composition as yesterday, with the noticeable addition of Madame Eva Kalb. But before this is our last day, our last hearing today. Allow me to take 1 minute of your time, please, to thank, last time, the wonderful team that has supported me all over these years. Some are in this courtroom today. Some are in the defense office. Others have gone their way in life and have now moved to another step in their professional career. I wish all of them success, and I thank them for having passed some time next to me. I will name them all, with your permission, by chronological order. The defense team members: Ahmad Issa, Vanessa Gray, Marion Carin, Mohamed Mana, Nina Guillot, Camille Divet, Paola Palo, Eva Kalb, Mohamed El Rai, Marcela Velarde, Audrey Matteo, Anen Khali, and Omar Soliman. Our wonderful interns: Laurence Boudreau, Marguerite Rémy, Nour Wardani, Iman Leroy Hadji, Esteban Oya, Drusilla Brett-Robertson, Thomas Châtelet, Pénélope Fouret, Claire Chauffard, Salomé Fischer, Valeria Oloub, and our visiting professional, Wilson Yu Acho. And last but not least, my outstanding partner and perfect match, Counsel Yen Edwards. I hope I forgot none. I thank them all, and their memory will remain precious in my heart. Thank you.
Yes, well, thank you very much, Mr. Latch. I have no doubt your team will appreciate that. I should say, I don't think it's the last appearance, because we've actually got to pass sentence, and that will be done in open court. But nevertheless, I take the sentiment. Yes, so if we can now return, I think, Mr. Nichols, you were, if I can put it that way, in full flood yesterday.
Yes, Your Honor. And for literally 1 minute, could we go into private session?
Yes, private session, please.
We're back in open session, Madam President.
Thank you, Your Honors. Turning now to some of the case law and just responding to my friends. Earlier, I think on Monday, Mr. Lauchi went through some of the case law at the ICTY, talking about how that affects or how it could inform your sentencing. Yesterday, my friend, Mr. Edwards, pointed out correctly, of course, that you're not bound by any of that ICTY or other ad hoc jurisprudence. But some of it is instructive, and if just responding to Mr. Lauchi, where he was going through Galich and some other cases, talking about the high rank and serious crimes of genocide in the ICTY, which drew life sentences. I think one case that wasn't mentioned that is worth looking at is the case of Milan Lukic. He was sentenced to life imprisonment, and I'll just look at paragraph 1084 of the July 2009 trial judgment. And this is under the headings in that case of findings with regards to the offenses committed by Milan Lukic. Para 1084. Having considered all the evidence related to sentencing, including matters of mitigation, the trial chamber maintains the position that on the basis alone of Milan Lukic's guilt for personally, physically, and in cold blood killing the 5 people at Drina River, the 7 people at Vardar Factory, the 59 people in the Pionierska Street fire, and the 60 people in the Bikavac fire and Hyra Koric, a total of at least 132 people, the maximum penalty is warranted. And there were some parallels between Milan Lukic in this case, because Milan Lukic was a paramilitary leader. He wasn't a regular VRS, equivalent of SAF member. He was a leader of the White Eagles or Avengers when he committed these crimes in Bosnia and Herzegovina. So, in some sense, parallel to a Janjaweed leader, also an irregular unit which fought alongside government forces and committed the crimes alongside government forces. So Lukic got life, and the total number was 132 persons that they found that he had murdered. 81 less than the accused in this case. He was, yes, Your Honor.
I know Starkic originally got life. You say Lukic got life. Was that upheld on appeal?
Yes.
It was it?
Yes, Milan Lukic.
Right.
Not his cousin
No,
or brother,
yeah.
not Stradoya.
No, right.
So he was convicted of extermination, a different, which, as we know, is murder on a massive scale. But nevertheless, 132 people, 81 less than the accused, and the chamber thought that, well, not thought, they passed a sentence of life imprisonment. That was upheld on appeal, and again shows that the core issue is not the rank, the de jure rank of the accused, or whether the crime was genocide, but the individual circumstances of the crime. I should say in the Lukic appeals judgment, you asked about, Your Honors, which upheld the life sentence, they did reduce the number of victims in one unit, one incident, the Pionierska Street incident, from 59 to 53. So it's not 132, it's 129 or something. But the appeals chamber wrote, however, the appeals chamber considers that the crimes for which Milan Lukic has been convicted are extremely grave. These crimes included extermination, persecution, and other inhumane acts as crimes against humanity, as well as cruel treatment and murder in violation of the laws or customs of war. In these circumstances, the appeals chamber finds that the reduction of the number of victims of the Pionierska Street incident does not impact the sentence imposed by the trial chamber. Consequently, the appeal chamber affirms Milan Lukic's sentence of imprisonment for the remainder of his life. That was para 669. A little bit now on I'll respond to the arguments relating to mistake of law and obeying orders. I won't rehash or repeat the submissions the LRV made on this, but you found in the trial judgment that the accused / a reasonable person could not believe that the acts and conduct were legal at the time. At para 59 of the judgment, I won't read out the entire paragraph, but you wrote, considering that, as noted above, the accused held a high-ranking position as a senior Yanyuid leader with a substantial set of responsibilities and powers, and that he spent a considerable part of his career in the SAF, the chamber is satisfied that a reasonable person in the position of the accused would not have been, quote, deceived, unquote, into believing that his acts and conduct during the charged events were legal or justified. So, in my submission, that issue is done. Trial's over. That is what you have found. And this is where we come a bit to the balance of probabilities mitigating argument. I fully accept what my friend Mr. Edwards said, that the chamber, of course, for any individual witness, it's not all or nothing. You can find parts of the testimony credible, parts not credible, give weight to some, not give weight to others. But at paragraph 32 of their submissions, the defense essentially assert that the chamber should reconsider. I'll wait till you find the paragraph. Essentially asking you to reconsider your finding in paragraph 59 that I just read from on the basis of a lower standard of proof or probabilities, balance of probabilities, in order to find mitigation. That doesn't work because you've already made a positive finding on this point that he did not act under mistake of law, and there's no evidence that such a mistake was made. Yeah. Yeah. So, and what the defense are asking you to do there, again, is look at it at a different standard, and they analogize in a different part, I believe, to duress, and say that, well, as the article Rule 145 2A1 states, even if the positive defense is duress is not made out, some of the circumstances may be mitigating. That's a very different animal. If you look at Article 31D of the statute, in order for the defense of duress to be made out, the chamber must find that the person raising the defense acted necessarily and reasonably to avoid the threat and did not intend to cause greater harm than the one sought to be avoided. So one can imagine a situation, something like Erdemovich, where, I'm not speaking about the accused, but a person finds themselves being forced, being ordered to carry out executions, and they will be harmed if they do not. They could put forward that defense. Trial chamber could say, no, it isn't made out because you are avoiding harm to yourself that doesn't allow you, that is not a defense to murdering 100 people. Defense doesn't fly. However, the chamber could say, in mitigation, though, we do take into account that you had a gun to your head and that you were under incredible pressure at the time. That doesn't transfer to, did you know or not know that these acts were criminal and that you could be punished for them. There's no halfway point there. So I don't think you can look at your ruling you've already made and say, yeah, but maybe he didn't know that much, or or he understood it but not really well. It just is not analogous and it doesn't work. That's my submission. I'll move on now to foreseeability and the change in law issue. Again, we all know it, but the trial is over. Your Honors found that a reasonable person in the position of the accused would know that they could be prosecuted for crimes, for criminal conduct, analogous to the ones for which he has been convicted. Again, paragraph 59 of your judgment and also paragraph 60. I'll read out paragraph 60. On the basis of the evidence before it, and having rejected all of the defense's challenges, the Chamber is satisfied that the requirement of nullum crimen sine lege found in Article 22(1) of the statute is met in this case. Sudanese law is not applicable in this court. Not to the crimes, the elements of the crimes, not to the penalties attached to those crimes. The Chamber in this court may only take into account when assessing foreseeability of crimes and punishment the law of this court, and potentially international law as well, in the sense that even under international law, the accused could have been aware that his conduct was criminalized and had serious penal consequences. That's noted in paragraph 88 of the Appeals Chamber judgment on the jurisdictional challenge. There, the Appeals Chamber wrote, in applying the foreseeability test to this case, the Appeals Chamber finds that Mr. Abd-Al-Rahman was reasonably capable of taking steps to comprehend and comply with his obligations under international law, and he was capable of appreciating the attendant penal consequences. Now, to the extent your honors would consider Sudanese law for purposes of foreseeability of penalties attaching to these crimes, rape, murder, torture, looting, etc., as we read in D16's statement, recent statement, paragraphs 24 and 33, those crimes carried extremely severe sentences domestically. Death, crucifixion, and a reasonable person in the position of the accused would have known that. A reasonable person in the position of the accused would know that serious sentences could be imposed both domestically and internationally. He could have been sentenced to death in Sudan for just one murder, let alone 213. So once the Chamber is satisfied that serious penalties were foreseeable at the time of the crimes, then it will apply the sentences in accordance with the Rome Statute, and the Rome Statute exhaustively. That jurisprudence is settled. We cite to these cases at paragraph 22 of filing 1248, and those are the Lubanga Appeals Judgment, para 32, Bemba et al. Sentencing Appeals Judgment, para 77. And the defense acknowledge in their sentencing submissions, paras 118, 122, and 133, properly, that Sudanese law doesn't form part of the applicable law of this court. And so, as I mentioned at the end, I think at the end yesterday of the hearing, Your Honors also noted this in your decision number 1257 at paragraph 17, that you are not bound by domestic sentencing practices and laws. And I'll just read that out very quickly. Paragraph 17 of your decision on the presentation of additional evidence. However, the Chamber accepts the CLRV's submission while deferring to the Chamber's discretion the admission of D16's evidence that the Court is not bound by domestic sentencing practices and laws. Accordingly, while the Chamber authorizes the submission of D16's new statement, it recalls that its reliance thereon for the purposes of sentencing may be limited, given the clear provision in the Court's statutory framework. But as I said, what the new statement does show is that severe penalties, much more severe than could be imposed in this court, were possible at the time in Sudan that the accused committed the crimes. And again, I'll just cite, I won't read it out, to paragraph 26 of the Ongwen sentencing judgment. Actually, I will read it out because it's there. Their Honors wrote, Article 23 of the statute provides that a person convicted by the court may be punished only in accordance with the statute. In turn, Article 77 of the statute specifies exhaustively the penalties to be imposed for the commission of crimes within the jurisdiction of the court. And that's it. That's it. That's the end of the analysis. Following the referral of the situation in Darfur to the court by the Security Council, the Rome Statute, the rules of this court are the only applicable legal framework for sentencing in this court. There's been no change in law of the statute or the rules to warrant any consideration of Article 24. The CRV made reference and spoke about Rudo and Sang, so I won't repeat that. Let me skip ahead. Well, again, I'll just go back to the Galich Appeals judgment, para 397 to 398. There, the defense for General Galich tried to argue and rely on sentencing practices in the former Yugoslavia, and that was rejected by the chamber. The appeals chamber in that case stated, the principle of lex meteor is not applicable to the relationship between the law of the International Tribunal and the law of the national courts of the former Yugoslavia. And the Galich Appeals Chamber recalled in paragraph 398, I'll just read it out. It is an inherent element of the principle of lex meteor that the relevant law must be binding upon the court. Accused persons can only benefit from the more lenient sentence if the law is binding, since they only have a protected legal position when the sentencing range must be applied to them. The principle of lex meteor is thus only applicable if a law that binds the International Tribunal is subsequently changed to a more favorable law by which the International Tribunal is obliged to abide. That's para 398. So the only relevant law binding Your Honors for sentencing is the statute and the rules. There's been no change to them that would warrant a 24-2 analysis. So whether or not Sudanese law for some of these crimes imposes 7 years, 10 years, or 20 years is irrelevant. If in Sudan he could be executed, crucified, it's also irrelevant to what sentence you pass in this case. And if you think about it, to find otherwise, and to really what I think the defense are saying, looking at the time that the crimes were committed, 2003 and 4, for their argument to really come together, the reasonable person in the accused position would have to have gone through the process of foreseeing if he committed these crimes, 2003 and 4, in Darfur, that the Security Council could later refer the situation to the court, which would issue an arrest warrant for him. After which, the Rome Statute would govern the sentencing, obviously, but he would evade justice until he was in his 70s. Then surrender to avoid problems in Sudan. Following that conviction, he would not be able to be sentenced to life for 30 years because he was over 70 and the Sudanese law should still apply. Therefore, it's unfair and he should be given the benefit of the change in the law. It just doesn't make sense. He knew his conduct was criminal. He knew his conduct could result in severe penalties to him in 2003 and 4 domestically. He should be now sentenced pursuant only to the Rome Statute and the rules. And as we've said, I won't repeat it, the arguments sentenced to a term of life imprisonment. And I'll stop there. Thank you.
Yes, thank you very much, Mr. Nichols. Yes, I think we now we return to Ms. von Wistinghausen.
Yes, Madam President, Your Honours. First, I would like to address very few of the submissions the defense has made, and then I will turn to what I call my conclusions, my wrap-up on behalf of the victims. Mr. Lauci spoke about the efforts made by his client to compensate the victims. And this is exactly what Rule 142(2) says. It speaks about any efforts by the person to compensate the victims. So we are not talking about efforts made by the defense or here, lead counsel. I'm personally really not sure that the sending of 160 emails to state and non-state parties to ask for earmarked donations came from Mr. Abd-Al-Rahman himself. At least I didn't hear this from you. In any event, I've already stated what I think about this move and of the fact that I consider it to be maybe unfortunately even counterproductive, which again, I don't think Mr. Abd-Al-Rahman realizes himself. It may be a nice sentiment, I give you that. But it's just not based in law, any of what you're trying to do. And it's misleading, in my view, the public and therefore also the victims, and more specifically the participating victims who I represent, Oops.
Is your computer saying it wants to
It's
update?
just my private computer that kind of broke down, but it's okay. I'm managing. So I'm saying it's, in my view, it's even misleading and therefore quite problematic, because I've lost my mon fil rouge, as you say, in French.
Do you want it an adjournment, or is it?
No. Don't worry. I'll just jump. Okay. What you have said, Mr. Lauchi, as well, which I think is wrong, also legally wrong, is that the victims would receive reparations, and I think we need to be very careful when we talk about these things in public. You said that, and I quote from transcript 164, page 72, line 16 to 19, that the defense will request and insist that victims will be afforded reparations nevertheless, whatever the outcome of the appeal. So clearly, Article 75.2 speaks about the convicted person. And as I already said on Monday, there would be absolutely zero reparations if Mr. Abd-Al-Rahman was acquitted on appeal. This is exactly what happened in the Bemba case, and there is a trial chamber decision to that effect, a final decision on the reparations proceedings. So I'm certainly not saying that the current ICC legal framework is the best for participating victims. I'm actually very far away from saying this. But as it stands, all the activities of the defense have absolutely no bearing whatsoever on reparations my clients may ever receive, if ever. So I really don't see how the chamber can consider any of this as a mitigating factor for the sentencing of Mr. Abd-Al-Rahman. It may be regrettable that the trust fund has nothing in place yet regarding reparations for the participating victims in this case, but I'm afraid this doesn't get any better by the actions undertaken by Mr. Lauchi, and I insist that I sympathize with the intentions of counsel, but here we have to look at activities or efforts made by Mr. Abd-Al-Rahman and nothing else. I also disagree that it would be unfair, and I think it's Mr. Edwards who said that, to bar an indigent accused from benefiting from a reduced sentence by demonstrating efforts to compensate victims. If I may say it a bit like clumsily or bluntly, that's life, you know. There's no rule stating that every convicted person should be able to benefit from all and the same mitigating factors. This is obviously very different from one convicted person to another and must be assessed by the trial chamber depending on personal situation and other circumstances. Further, the defense keeps repeating that Mr. Abd-Al-Rahman explained solidarity towards the victims. So I still don't know, actually, which victims Mr. Abd-Al-Rahman is talking about. Is he speaking about all the victims of the conflict in 2003 and 2004? Is he speaking of all the victims from 2003 until today? Is he speaking of all the victims of the crimes committed in Bindi, Sikoldoum, Delej, and Mukjar? Is he speaking about the participating victims in particular? It's still completely unclear to me, and the submissions of Mr. Lauchi, I'm afraid, haven't enlightened me in any way. So in any event, I explained before that my clients don't accept this solidarity, given the harm and trauma that they have lived because of the crimes committed by Mr. Abd-Al-Rahman. Yes, I agree, Mr. Abd-Al-Rahman has no control on how his expressions of solidarity are received by the victims, but it's also the result of the three defense lines that he has chosen, and I think he has to bear the consequences. So this is just what I wanted to say in response of what the defense said yesterday and on Monday. And now I would like to move on to my final conclusions. And it will take me about 20 minutes. So we've set out in detail the voices of my clients in our written observations, and I'm not going to repeat this. It's publicly available. And as we said during this hearing, we addressed everything that the defense has said in their written submissions. There's one point I want to pick up on is a suggestion or question actually the presiding judge had to Mr. Nichols. And it was about the question on the psychological harm suffered by the victims. Without going further into detail here, because I think we have addressed it in extenso, but we can refer the chamber to our final trial brief in a section entitled Psychological and Emotional Harm at paragraph 317 to 330 for a, we think, very comprehensive overview of the psychological harm suffered and what more specifically it means. So, what do my clients expect from me to say here today? And of course, a lot of what I say is my translation of what they have said to me. And as you know, when we can, we use quotes, and I will do again. But when I don't, I stress it is indeed my translation, and I hope I get it right. So they say justice for them is not an abstract concept. It's not just a line in the judgment. It's the recognition of a truth that was long denied to them. Because what happened to them, it was not an accident of war. It was a campaign of extermination, humiliation, and displacement conducted and ordered by no one else than Mr. Abd-Al-Rahman, and nothing more, but also nothing less. It's what they asked to be reflected in the sentence that you will impose on him. His conviction in the trial before this chamber for the participating victims and the wider community in Darfur, we agree with the defense, is historic. And it is the first arising from a Security Council referral and addresses the situation in Darfur in 2003 and 2004. It was certainly long awaited by the people of Sudan and victims in particular, and we saw it actually after the judgment. People were on the street and with very visible reactions, not only the participating victims. It is the first acknowledgement that the people of Darfur were not victims of mere intertribal conflict or something alike. They were victims of a deliberate campaign, the chamber made it very clear, orchestrated by those in power and executed by the Janjaweed, led by Mr. Abd-Al-Rahman in the Wadi Saleh region, under the authority of the government of Sudan, even if not specifically ordered by anyone in particular. I found this a very interesting reaction that we got from clients after the judgment, and we connected to them via video, is that they addressed exactly this, that for them it was also very important that the historic record was, how do you say that? The record was, you put the record straight, I think this is the way you say it, right, for them. Because still in the community there's a lot of discussion of what has happened and why. And the summary that you gave for them was a relief, actually, you know, to get a clear account of what it is actually that happened, and not a purely tribal thing. So this judgment already carries a symbolic weight far beyond the wars, but also is a historical weight unless at least for the victims. It finally tells the people of Darfur that the world has not forgotten them. That's also an important aspect. And that even after 20 years, justice is possible. The reaction of the judgment, messages and pictures we received are worth 1,000 words. I already mentioned this. But it's important to reiterate, to demonstrate how meaningful such a trial is in times where the court and its relevance and the meaning and the weight of international criminal law is subject of constant, very controversial debates. So before I speak about law, I must speak about the people who we constantly mention here, as unanimously, but also as anonymously, actually, as we do, the participating victims. Since the beginning of these proceedings, and I have rehashed this time and time again, my team and I have sought their views and concerns. We try to do this across Darfur and the refugee camps in Chad, which, given the circumstances, is a quite difficult undertaking. Despite the war, despite displacement, despite poverty, despite the resulting constant stress, many of the participating victims found the strength to individually speak to us, with the wish that we convey to you through letters, audio messages, and meetings under the most fragile circumstances, and that we make it clear. They do not call for vengeance, and they do not call for hatred, because they are smart. And they know it wouldn't help at all, even though it would be the most natural and understandable avenue. The first thing that comes to mind, even I think to all of us, if we're honest, leaving aside our supposedly clever mind as educated jurists. The victim's approach is actually minimalistic, but so clear and much more resilient. They call for justice, for acknowledgement, and they are asking for peace. Peace built upon accountability. That's the only thing we can provide in this courtroom. They, of course, have their own views on how this would best be achieved. It may require translation again. But at the end of the day, they call for protection from ever again living in fear of the man who once commanded their destruction. It is as simple as that. It doesn't require much legal debate on which law to apply. My colleague, Ms. Beaulieu-Lucier, has very well explained. Sudanese law wouldn't spare Mr. Abd-Al-Rahman for an inch, given the gravity of the crimes he committed, also under his own jurisdiction. And Mr. Nichols has repeated this today. Your Honours, the words we heard most often were these: he must never return to Darfur. This is the primary concern. For many, even the thought of his return causes trembling and panic. The memories of his presence are carved into his mind. They have seen his men drag fathers from their homes, burn their villages, and assault their mothers and daughters. One man has said to us, if he comes back, he will start again. He will commit new crimes. End of quote. Another said in simple words, if he returns, the pain will return too. Let him stay where he belongs, in prison. End of quote. I'm told to slow down. Your Honours, the crimes committed in Kudum, Bindisi, Mukjar and Delej did not end when the killing stopped. Entire families were annihilated. Those who survived have carried the grief of their dead for 20 years. Many could not even bury their loved ones, a cruelty that deepens the wound every day until today. The victims also spoke of the loss of entire ways of life. Displacement was not only a physical uprooting, it was a tearing apart of culture, tradition, and social order. The four people lost their elders, their sheikhs, their umdas, their shartais, the traditional leaders who held the society together. Without them, a whole system of governance and identity completely collapsed. And the women, Your Honours, the women of Darfur have carried the heaviest burden. They were left to raise their children and orphans alone, in camps, without security, without resources, without justice. Too many of them have been raped, widowed, and humiliated. Yet, they still stand firmly. They raise their children, even those born out of rape, but they are exhausted. However, they say they will not give up until justice comes. V4, you may remember him, when he addressed your honors, highlighted the role of and the respect for women in the Darfuri society. And this was in transcript 127, page 60, lines 13 to 19. And he said, "The Darfurian women remain dignified, firm. They are iron ladies, and justice will be rendered, hopefully, and the future will carry the best for them. We respect and appreciate women. Women are mothers, sisters, and everything." And to quote a poet, it's him quoting a poet, it's not me, "The hand that rocks the cradle is the hand that rules the world." However, these are not stories of the past. They are stories of the present and come from the participating victims in this trial. These women still live in Kalma camp and in camps close to Bindisi, Kodum, Delej, and Mukja, where the villages were, and some as well in Chad. Today, just as the day of my opening address on the 5th of June 2023 it was, they still suffer from hunger and fear. But the difference now is that your honors have decided and publicly stated that the accused is guilty of the crimes that he was accused of, and he bears individual criminal responsibility, and that what was done to the participating victims was fundamentally wrong. Many of my clients didn't even believe something like your judgment was within the realm of realistic possibilities during their lifetime. So turning to the legal requirements for sentencing, Your Honors, I will make it short because you know it very well. The Rome Statute provides a clear framework for sentencing. You must consider three things: the objectives of sentencing, gravity of the crimes, and the individual circumstances of the convicted person. So starting with the objectives, the court has often affirmed that the main purposes are retribution and deterrence. Retribution, not as vengeance, but as the moral condemnation of what the international community considers or has agreed to be the consensus. The court said it in Bemba. Retribution is not to fulfill a desire for revenge, but to express the international community's condemnation of the crimes, to acknowledge the harm inflicted on the victims, and to promote peace and reconciliation. I agree this is a very high aspiration, but maybe we can try to get any near this high aspiration. The victims of Darfur understand this distinction deeply. They do not want retribution to destroy, but they ask for retribution to restore. They want this sentence to stand as a declaration that their lives matter and that their suffering is not invisible. Also, this sentence must serve as a warning to anyone who believes they can command militias, burn villages, rape women, and destroy communities with impunity. As one victim, I call him Abkar, told us, "Let this be a lesson to all those who think they are above the law." Many participating victims see that their hope materialized and that justice eventually comes, no matter how long it takes and how small it is compared to the real sufferings. However, a sentence also needs to be adequate to discourage a convicted person from recidivism and for history to repeat itself. A possible scenario, as expressed by a group of victims from Gosbeida, this is a camp in Chad, is that, and I quote, "The moment he returns and sets foot on Sudanese soil, he will pick up his axe and continue what he has always done." This fear is real, as unrealistic as it may seem to us. In our comfortable European lifestyle, it is not made up. Many participating victims can't erase the pictures that they are carrying with themselves now for decades. As a result, I respectfully disagree with the defense's argument that the age and health of Mr. Abd-Al-Rahman render this consideration irrelevant. For ordering, a mode of liability Your Honours convicted him for, young age and perfect health are not necessary. Regarding the gravity of the crimes, Your Honours, you have now repeatedly heard from all of us that the crimes for which Mr. Abd-Al-Rahman was convicted are among the gravest ever heard and debated before this court. As the Chamber has found, they were systematic, committed on a large scale, and motivated by discrimination. They targeted civilians, men, women, and children equally, solely because they were fous, and therefore deemed enemies of the state. The attacks on Bindisi and Kudum were carried out with deception and cruelty. The Janjaweed told the villagers they would not be harmed. Then they surrounded the villages and slaughtered the inhabitants, killing men, women, and children alike. Many were burned alive in their homes. Others were beaten with rifle butts, whipped, or executed after being tied up. Women and girls were raped, often in public, in front of their families, to degrade and terrorize the community. Some were murdered immediately afterwards. We can all read this in your judgment. These acts were not isolated incidents. They were part of a deliberate plan to humiliate, destroy, and erase the poor people. The murders, the torture, the looting, the persecution, the forced displacement, all were components of a single, coordinated policy of extermination. Even after the attacks, the cruelty continued. Men and boys were detained, tortured, and executed in Mughjar and Delej. One detainee had his ear cut off in the presence of Mr. Abd-Al-Rahman. Others were beaten until they could no longer hear, walk, or speak. Some died from starvation and disease in detention. This was not chaos, it was control. This was not a spontaneous uprising, it was a policy. And the Chamber found that Mr. Abd-Al-Rahman was right at the center of these events, leading, ordering, encouraging, and taking part. Your Honours, the suffering of the participating victims is not confined to the past. Many still live in displacement camps struggling for survival, and you've heard from some of them here in the courtroom. We have extensively demonstrated this throughout the proceedings, in writing and orally, and as you will appreciate, they all remain impoverished, traumatized, invisible to the world and the country at war again. The Rapid Support Forces, born from the same Janjaweed structure, are now fighting the Sudanese army. The victims of 2003 now witness their own children facing the same horrors. This reality adds urgency to today's proceedings. Your Honours, the victims' demands are remarkably consistent and reasonable. They call for a sentence that reflects the enormity of the crimes and that doesn't allow for Mr. Abd-Al-Rahman to ever again set foot on Sudanese ground. Following discussions and explanations regarding the judicial process, because I've tried to explain to them, or I have explained to them, and they well understood the legal framework, most of the victims have demonstrated a high degree of understanding and have largely reaffirmed their trust in the proceedings and in Your Honours. Ultimately, they have no choice and accept the legal and jurisprudential framework as it stands without excessive criticism, even though it's far away from their own national legal framework. Still, following the defense's submissions on the appropriate sentence, a group of participating victims from Gosbeda in Chad voiced this clear view, just on Monday, and I'm quoting, "We wonder that at the same time that we, as victims, are told that we cannot demand his execution, although such penalties fall under Sudanese domestic law, how is it now acceptable for Sudanese law to be used in his favor?" End of quote. They questioned how Sudanese law can be used to shield Mr. Abd-Al-Rahman now, when that same system failed to protect them failed to prosecute him and failed to uphold even the most basic standards of justice. And another quote is the following: "He is currently detained and tried by the International Criminal Court that is governed by its own rules and regulations. Therefore, he has to be held accountable solely under these provisions." End of quote. I concede that this is just a view of a participating victim, not a lawyer, not a jurist. But I think it's interesting to share with you what the feeling of justice is amongst the community. They even state that, and I quote, "If Sudanese laws had been properly applied, the people would not have turned to and supported the ICC in the first place. It was precisely due to the failure of the courts, the injustice of the judiciary, and the lack of impartiality and enforcement of the law that people accepted and supported the ICC's intervention." End of quote. Further, understandably and in line with the principle of proportionality, one victim said, and I quote, "His natural place is in prison for many years, so that he may also feel the suffering that was inflicted upon us in the camps." End of quote. And another said, and I quote, "We want him to live the same number of years in prison as we have lived in the camps, in displacement and suffering." End of quote. This group of victims from Gosbeda expressed the clear and consistent wish that, and I quote again, "the accused remain imprisoned for life." They explain this request by saying that even if he were to live only one additional year, they needed the reassurance that he would spend that year in detention, having lost the right to freedom that he denied to them. They viewed a life sentence as the only punishment proportionate to the sentence that he imposed upon them, and they continued to live to this day. These participating victims also expressed grave concern that if the accused were ever to return to Sudan, he would immediately resume the conduct for which he was convicted. The wish of these participating victims, I would say, is not cruel. It's profoundly human. They definitely ask that he never return to Darfur, not only for the sake of punishment per se, but also to protect their peace and dignity. For them, justice means more than imprisonment. At least this is my understanding from what they told me. It means recognition that their pain is heard, their stories recorded, their dignity restored, the first step of which the judgment on 6th October was, with the important historical record it encompasses. We often heard from clients that they want the world to know that they were targeted because of who they are. They were not rebels, they were human beings, innocent civilians. Another fact that needs to be reflected in the sentence. And yet, many victims also expressed humility and trust in this chamber. I heard from them, after having explained the ICC legal framework, and I quote, "We are not lawyers. We leave the judgment to the judges. We only ask that the punishment be just." End of quote. But justice also means speed, because time itself has become another form of suffering. Victims have waited 20 years. Many have died waiting. Those who remain hope to live long enough to find closure. They want to see the sentencing decision come quickly. They seek acknowledgement. And they seek assurances that what happened to them will never happen again, not in Darfur, not anywhere. So for these reasons, I respectfully urge this chamber to impose a sentence that fully reflects the gravity, cruelty, and enduring impact of Mr. Abd-Al-Rahman's crimes. A sentence that affirms the humanity of the victims and the authority of the law. A sentence that tells the participating victims, in this case, that some form of justice has finally arrived. Thank you.
Yes, thank you very much, Ms. von Wistinghausen. Yes, Mr. Lauchi. Mr. Lauchi, I'm proposing to sit through to finish. So you said you were going to take one session.
Yes, precisely, Madam President. It's one session. I have heard my learned friends, and yesterday I made the request for the favor to have a short break before I start in order to
Oh, you did.
digest.
You're quite right. You're quite right.
Can I offer, because that would be enough, for, actually I'm not offering, I'm proposing, that the courtroom takes the break a little bit earlier than usual, but the length of the break does not need to be longer.
No, well, I'm not going. I was actually going to shorten the break.
Okay, sorry.
And say on the basis that 20 minutes would be sufficient.
It is.
Right. In which case, well, I suppose actually there's not much difference. All right, we'll say 11 o'clock. Yeah. Just one matter. You appreciate that if Abd-Al-Rahman wants to say something, he needs our leave. Are you asking for that?
Yes, we are.
And how long?
The assumption is maximum 10 minutes. Well, the 10 to 15 maximum, absolute maximum.
Right. I want to make it clear. All right, well, the best laid plans and all the rest of it. I'm told that because the public gallery has got people in it to clear and we have to have the full half hour.
Ah.
So that will be, so we'll sit again at 10 past 11, it looks like, by that clock. Yes, you also mentioned that he may want to repeat the request he's already made twice before in respect
No.
of
Sorry.
asking for silence.
No.
He's not.
No.
Right. Okay. Thank you very much. Yes. All right then. 10 past 11.
All rise. We will.